the other law enforcement agencies, including the SEC and all that, they find them. And there is something called a class action suit, which is now available in India also. So, and recently, British Airways, they were fined under GDPR 20 million pounds. 20 million pounds, which is a big amount, because they also led to the breach of the data. And now let's see how much Air India has to face, because according to the Indian uh, existing law, up to 5 crore rupees can be the fine and compensation for each and every data which got breached. 5 crore per person. So that is the reason the cyber criminals are flocking to companies to get their data, and that is the reason the compliance professionals and we are all must be looking to protect our data in our companies, in our homes. As we move, we will see the legal provisions also, that which part of the Companies Act, which part of the IT Act provides for the penalty and compensation, and what it is actually meaning. And in India, it is not only the civil liability which I have talked about, the amount, that same liability also converts into criminal liability, because the law which is provided in the section 43 of the IT Act, the same offences can be considered as criminal offences under section under criminal sections of the IT Act. Now let's have a look at some of the offences which the individuals and corporates are facing in terms of the cyber crimes. Some of them for the individuals are sex offences, luring for money and sex, drugs related offences. There are illegal red parties, plain burglary and dacoity, defamation, bullying, stalking, pornography distribution, credit card, debit card, Paytm, e-commerce fraud, fake IDs, fake emails. Now on the cyber bullying part, everybody I would request and suggest, please visit my YouTube channel, and we have a fantastic interaction on Rajya Sabha TV on the cyber bullying, which is one of very good programs, where we had very nice speakers, including DCP of cybercrime from Delhi Police. So just please go to this link, and you will find a full 1 hour video recorded at Rajya Sabha TV, RSTV. So this will give you a very nice perspective on cyber bullying. So these are some of the offences which individuals are facing. Some of the offences or the crimes companies are facing: abuse and misuse of computing assets, email abuse, internet abuse, potential criminal conduct using company premises and computer network and other IT infrastructure, financial frauds, industrial espionage, corporate sabotage, embezzlement, data theft. Now, there are many examples I would like to quote on each and every of these crimes, provided the time permits and your interest is there. Because I must tell you again and again, these are now becoming on a routine basis. And as and when something goes wrong, company secretary, chartered accountant, advocate is the first port of call for the management. वकील साहब बताइए क्या प्रॉब्लम आ गया, we need to handle this, we need to take care of this, kindly help us understand, kindly help us mitigate, and kindly make us proof from any kind of a liability which we as a corporate end up facing. Now we are just going to have a little discussion on some of these cyber crimes in little details. It will not be possible to discuss all the problems which the companies and the individuals are facing, but yes, we must understand some of them. And the first thing we are going to discuss is APT, Advanced Persistence Threat. Now, as the name suggests, that this is a threat which is a persistent threat. It is always existing. And the word advanced means that it is a very advanced technical nature. Now, what are these advanced persistent threat? Data breach, password theft, theft of IPR, designs, R&D information, and employee personal sensitive information is done by hackers, and on an average, the average time spent for an APT to be successful is 229 days. So, a typical hacking or data breach, it is not an overnight job as we see in various movies. It takes the hackers or the cyber criminals a lot of time and effort, and hence it has become an institutional activity. There are large distributed cyber gangs. So they are distributed across the countries and continents. Sometimes they are even getting the government support to commit these kind of crimes. They are well funded, obviously technologically very advanced. And the people on the receiving end, typically the corporates, public sector undertakings, government departments, defense establishments, and any place which is holding sensitive information is always a target of advanced persistence threat. For example, we are holding all Indian sensitive personal data, including biometrics, in UIDAI. This UIDAI database, which is under the control of the central government, is always a target of APT from not only criminal gangs but also criminals supported actively by state actors. The name of North Koreans, Russians, Chinese are taken many a times, that they are pretty active in stealing the data. And we have seen a very recent breach, Air India. It's a huge breach. Almost data from 2011 is gone, and it is estimated that 11 million records have been stolen. The other threat, what we call as perimeter and insider breach. When you see your company's computer systems, the data which is kept there are typically two layers of security which normally the companies are keeping. One is called perimeter security, which is also given a different name called firewall. And then the other layer of security is insider breach. Cyber criminals work on these two to gain entry into your network. Now, in terms of understanding what a perimeter security can be, those of you who knows Ramayana and in Panchavati, where the Marich came in the guise of a golden deer, and Ma Sita asked Bhagwan Shri Ram to go and get that deer. As Bhagwan Ram started hunting the deer, went inside into the jungle, the Marich, which was disguising as a deer, when the Marich was hit by an arrow from Bhagwan Shri Ram, he made a voice as if of Bhagwan Shri Ram calling for help. Ma Sita asked Lakshman to go. Before leaving, Lakshman drew a Lakshman Rekha saying, please do not go outside, nobody come inside, you are safe inside. But what finally happened? That security line, the Lakshman Rekha, was impregnable, it didn't work. But what happened? Ma Sita came out and there was a security breach. So what happens in a company also, even if they have gone and put some security measures in place, employees themselves do something which is against security policy and open the company to cyber breaches. It is very, very important from the corporate perspective that not only they put sufficient security measures in place, it is also for the employees and other stakeholders who are utilizing those IT resources to follow company policies and do not let to any scenario which can lead to criminals getting inside or information going outside. Like we have seen in the Panchavati episode in Ramayana. Another kind of problems, email spoofing and email server compromise. So what happens that if you are the CFO of the company and you get an email from CEO at company.com that immediately release $1 million funds to so and so company because we have got a very nice deal done with them, CFO will tend to do it. But that email can be a spoof or a fake email actually coming from a criminal, not coming from the CEO itself. Data theft and transaction compromise, we had been talking about that. Ransomware is another major threat which is now becoming prevalent. As I have mentioned to you about the colonial pipeline attack, the company remained out of business. They could not do any work for almost 5 days, and it led to increased pricing of oil in certain areas of US, which is a very advanced country, technologically advanced country, and it is presumed that they have paid $5 million as ransomware to get the keys and to get their data back. This ransomware is a problem even to individuals. I repeatedly receive many calls from individuals that, sir, we have been hit by a ransomware, kindly help us. In most of the scenarios, ransomware decryption is difficult or impossible. Another aspect of cybercrime is women employee harassment. I have received many calls, investigated many matters where people within the organization have sent email, inappropriate emails from Gmail or other emails which are presumably private in nature, and those emails were containing lewd remarks, some very inappropriate content. Now, if that happens, it is obviously an embarrassment to the organization who is employing women employees, as well as a criminal liability to the organization. So this is something very important. You must ensure that in your employee policy, Such kind of things are written in bold, and all your employees must be following a certain etiquette, not doing anything which leads to women employee harassment under any circumstance. Now, I would like to show you a little video. Give me a sec. Is it visible, sir?
Yes, sir, it is visible, sir.
Just please watch it carefully. Please watch it again. What happened, sir? Can anybody tell me what happened? Just anybody, please. Any idea?
The ransomware hit the network.
That is what happens, whatever we see, we start thinking in that direction. Anyway, so it was a typical example of what we call as a watering hole attack. It was not ransomware hitting, sir. It was what is we call as watering hole attack. Now, what is a watering hole attack? In the video, we have seen that there is a pond, there is a place where the water was stored, and an animal was drinking the water, which is a typical case in a jungle. The animals keep coming and start drinking water, and a ferocious crocodile hit, which was otherwise hidden inside the water, to that animal, and that in a flick of second, that animal is gone. Now, in a cyber crime environment, we also see many of these watering hole attacks. But everybody must be thinking that where is the linkage? Where in the internet we get ponds, lakes, streams to store water? We do, sir. And these are our social media platforms. The internet platforms, the WhatsApp, the Twitter. So whatever we see there, and whenever we go there, and there are almost everybody going there, and we start believing it to be a safe place. We start believing it to be the correct place to be in. We simply stop believing and feeling that there might be criminals hiding out there. There might be people who are providing false, fake information. There might be predators hiding there, waiting to pounce upon anybody who is vulnerable. So we keep on hearing a lot of people becoming friendly on WhatsApp, becoming friendly on Facebook, and then offering something interesting. For example, two persons become friendly and one person offering a crore rupees gift, which arrives and a phone comes from the customs saying you need to pay the custom duty, and the person pays in the bank account of that so-called customs people some 5 lakh odd rupees, believing and considering that even if the friend doesn't pay that 5 lakh rupees, his gift is worth 1 crore. So that person is still in the profit of 95 lakh rupees. The moment that money is paid into that so-called custom account, that friend goes from the Facebook, and the person who has paid 5 lakh rupees into that so-called customs account lands up in the cybercrime cell police, requesting to investigate and get them back their 5 lakh rupees. Now, this is where the problem is. Now, this is where the problem is that whatever we see on the social media platforms, either as an individual or as a corporate executive, we start believing that as true, which is normally not the case. We must always see things with a pinch of salt. We should not be believing these things as they are appearing to be correct. Then we have some other kind of things, revenge bomb and organizing mob violence. Now these are of recent origin that many mob violence, for example, this 26 January Kisan Andolan violence, or earlier some Dalit Andolan, these are now being organized using the social media platforms. Email spoofing, I have spoken to you. So these are some of the issues which are coming again and again. You know, these are we are getting these spoof mails where we see a mail coming from say ICICI Bank and saying, there we have received a request to disable our ICICI internet banking login access, and if you did not send this request, kindly do something, 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 and make a make an entry using this particular link which is provided, which is basically a fake link, which is a data collection link. These days we are getting a lot of links moving around in the WhatsApp columns, something saying that Zio is now giving 1 year free data. Something is saying that there is a Pradhan Mantri relief fund being distributed, so please register. And then obviously, a lot of these vaccine messages are moving around saying, please register if you want an early vaccine date and things like that. These are all fake links moving around. There are links coming from presumably income tax department saying there is a refund and you immediately log in using this link. Please be aware and do not fall prey to all these kind of links. Take them with a pinch of salt. These are spoof links. These are data collection links. These are the links which are spreading malware, viruses, trojans into your phone and into your computers. So it is always desirable that we must ensure that we are not getting into these kind of links. We are not entertaining any information from those links, and this is not something which you ever entertain unless you are very much sure. Until unless you are very much sure about this, you must not ever entertain these things. You must not. Now, some of the threats in a typical corporate environment, I'll just go through very quickly. There are a lot of companies which are allowing employees to bring their own devices, BYOD. Then companies are also allowing some of the clients and vendors interface to their system so that data moves seamlessly and there is no second or third time data entry. Companies are connecting to the banking and other companies computer systems for easy and fast data transfer. That is obviously desirable. That is obviously desirable, but that leads to and opens up some of the issues where people are able to get into a corporate network. If I just go back to that target example which I discussed earlier, where more than 5 crore customer data was stolen, that particular threat vector or the virus, for simply speaking, actually entered into the target network from a vendor system, and that vendor was actually a AC vendor. That vendor was actually a AC vendor, air conditioning system vendor. So the interconnectivity with other kind of stakeholders are also leading to lot of cyber risk in a environment. And then certain, am I audible?
Yes, sir. Yes, sir. Now you are audible.
Okay. So then there are Trojan horses, there are zombies, there are applets, there are scripting languages, certain programs or certain messages coming to you, or even Excel files coming to you, Word file coming to you. They may have some small applet or scripts which may be actually leading to Trojans being introduced into your computer, and if it comes into one computer, it then can go to the entire network and all other computers within the network. Virus, microvirus, ransomware we have discussed. There are some different kind of threats. Integrity. So when we are doing transactions with the depositories, integrity is a major issue. DOS attacks are happening. Wireless network threats. Now almost all the houses are connected with Wi-Fi. A lot of people are working from home. Even offices also, the connection to computers are actually through Wi-Fi, and that allows any criminal to simply drive or sit outside the office, because these signals are available even the outside the home or the office, and connect into the network by breaking the password and stealing the data. For any company to work securely, these are some of the key requirements: secrecy, integrity, availability, key management, non-repudiation, and authentication. For any business to succeed in an electronic environment, these are the key elements. If any of these things are missing in your business relations, in your business dealings, you can never be a successful entrepreneurship. You can never be a successful business if your data integrity is missing, if the secrecy is missing, if the availability is missing. So, for example, if during this presentation, if we are talking for 10 minutes, we are not available 5 minutes, we are again available for 10 minutes, we are then again not available for 10 minutes, people will simply lose interest. People will simply lose flow, and they will probably not again join any such presentation, thinking that this is not at all a coherent kind of a presentation. This is never a likable form until unless you have ensured the availability. Non-repudiation. So what if I am conforming to a transaction using electronic means, and later on I say no, no, I am not too sure who actually sent it. We have seen many politicians repudiating their Twitter remarks later on, saying an employee was operating this or a child was operating this. I never intended to say so, etc., etc. So if that is the scenario, the credibility of that organization and that medium also goes. So the transactions which are happening in the E mode should be non-repudiable, and they should also be authenticated in a legally form, so that later on If there is a dispute arise and the matter say goes to authorities or to the court, they should be able to be held authenticated and enforceable. Some of the technical means which a company can take to ensure cyber security. This is I am also taking from the compliance perspective. Whenever you are doing secretarial audit or financial audit, kindly ensure and ask these questions to the client whether they have any kind of encryption, firewall, what kind of a network security protocol they are maintaining, whether they are allowing access from home using virtual private network, do they have any kind of a tunneling proxy agent system, what is their mechanism for any kind of an intrusion detection. So if there is a hacker coming into their system, how are they going to identify that? Or if there is a Trojan, or there is a virus, if there is a malware coming into this, how are they doing it? And then how are they ensuring that only genuine employees are entering into their network? So what is the authentication protocol? What is the access control they are having? So it is very, very important for any kind of an auditor who is going to certify that organization to be fit to be dealing for outsiders. These kind of questions you must be asking: encryption, network security, virtual private networks, tunneling, proxy and agent systems, intrusion detection, authentication and access control, and obviously the firewall. Now let us look at a little bit about the requirement of compliance. Then it is not only that I am saying that you should be doing compliance in your company, or whenever you are going for audit, you should be looking for compliances. Even the secretarial audit or financial audit requires some of the compliances. Why? Because there is already an RBI cyber security framework for banks. There are RBI guidelines for payment aggregators and payment gateways. There is RBI cyber security framework for urban cooperative banks. There is a SEBI cyber security and cyber resilience framework. There is an UIDI AU KU compliance security audit. Even in the Companies Act and the regulations, financial audit, everywhere, wherever you are doing and and declaring, you are declaring the company to be audited by you. And audit actually means to the outsiders that look, I have gone through the records, the procedures inside this company, and I have found them in consonance with the prevailing practices as defined by either the best practices of institute or regulations, or if there is something in the law, or as per the guidelines of the statutory authority or the sectoral regulators. So if there is a financial institution, NBFC, bank, they are under RBI. If it is insurance, they are under RDI, IRDI, and if they are listed companies, SEBI, so on and so forth. Now, what is the security policy? When you are going for a compliance regime or a mechanism, what do? You do a complete written document which is called a security policy. Now, security policy is a written statement describing which assets to protect and why they are being protected. Asset here means electronic assets, digital assets, who is responsible for that protection, which behaviors are acceptable and which are not. So a comprehensive security policy which is either written as per ISO, which is either written as per CIS, NIST, GDPR, anything. So there are different paradigms, there are different standards prescribed by different agencies, but they all lead to these basic questions being answered: that which assets to protect and why they are being protected, who is responsible for that protection, which behaviors are acceptable and which are not. So how do we do it? First step in creating a security policy, determine which assets to protect from which threats. And then what are the elements of a security policy address? Authentication, access control, secrecy, data integrity, audits. These are what we also discussed. The essentials of commerce using electronic means: secrecy, integrity, availability, key management, non-repudiation, authentication. So anybody who wants to conduct commerce, business, transactions using electronic means, he must ensure these points, and then only that person, that organization can be successfully doing it. Now, how do you do it? To secure your organization and to write your security policy and have a total secured framework or a compliance framework, what you need to do is IPDRR: identify, protect, detect, respond, and discover. Identify internal and external cyber risk. Identify internal and external cyber risk. Protect your organizational systems, assets, and data. Detect system intrusions, data breaches, and unauthorized access. And then respond to any potential cyber security events. If somebody is able to reach you or breach you, you must
Also, we are not able to start.
Is it? Am I now audible?
Yes, sir, yes, sir.
Okay. So what I was saying that you need to go for IPDRR: identify internal and external cyber risk, protect your organizational systems, assets, and data, detect system intrusion, data breaches, and unauthorized access. And this is what all being done in the electronic environment, mostly automated. And then respond if there is a data breach or somebody has already reached your gate. You need to have a mechanism in place to respond and then recover. What if there is a data breach? What if there is a cyber crime happening in your organization? You must have a policy, you must have a plan in place to recover your business, because continuity is very, very important from the business perspective. You cannot say to your customers, look, for 5 days we are not going to work, another 1 month we are on a holiday because our data has been breached. As we have seen in the case of the Colonial, that for 5 days they could not do normal business, which is a huge loss in various terms, not only the loss of business, but also the face loss and potential liabilities, civil and criminal. Obviously, what you need to do, you need to first of all get yourself trained to understand the cyber crimes, frauds, what kind of threats, what kind of hygiene, preventive and remedial measures. Training is always the first step in the cyber security. Now, next two slides, I'm going to talk about if you are a small office, what sort of IT infrastructure you can maintain, which is very cheap, which is not at all costly, and it still gives you some level of security. So, from the user and between your server, what you can do, you can have VPN plus encryption and a firewall. This is not at all costly. So this kind of a small office structure one can maintain, that you have a firewall which sits in between your file server, data server, and which allows connection to your various users. And it is always desirable that if users are connecting using the VPN plus encryption. VPN plus encryption. If you are having this simple kind of a structure for small offices, I am talking. Large offices, obviously, their systems are much more complicated, and when they need to take expert help in ensuring a plan, ensuring a structure in their companies, in their network to secure it. But for a small company, if that is the kind of data structure, if you can carry, that will help a lot of that will take care lot of potential problems you are going to have. We can take a couple of questions if allowed, and then we can move on to cyber law, or shall we finish it and then take up the question?
Sir, can you do question and answer session at last time?
That is all fine. I have no problem.
Yes, sir. Yes, sir. Thank you, sir.
So now we have been talking about uh, cyber crime, the types of the cyber crimes the corporates and individuals may face, and the compliance perspective, what can be done, or from the technical perspective, what all can be done to ensure cyber security and ensuring that companies are not facing potential cyber breaches and the liability. Now we are going to talk about cyber law, IT law from the commercial as well as from the criminal end. IT Act 2000 is the primary law, which is considered the law for now look at section 3 of the IT Act. Subject to the provisions of this section, any subscriber may authenticate an electronic record by affixing his digital signature. A lot of people keep on asking me that during this time, when it is difficult for them and their management to physically sign documents, can they use images of their signatures as a replacement for physical signatures? Yes, they can. Nobody can stop anybody doing it. But are they legally tenable? This is the answer we're going to get from this section 3. That the electronic records can be authenticated only by affixing the digital or electronic signatures as prescribed in section 3 of the IT Act. And an image of a signature is not a digital signature. That is only an image of a signature. That is not at all a signature or a digital signature. We need to understand what is an electronic record. Means data record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfilm. And an electronic signature means authentication of any electronic record by a subscriber by means of the electronic technique specified in the second schedule and includes the digital signature. So what a digital signature can be, it can be as per the second schedule to the IT Act and not otherwise. Not otherwise. So there are certain software vendors who are claiming some kind of a technique which they are employing, say Acrobat or something, claiming that they are digital signatures and they are as per IT Act. No, none of them are. Now, what led to e-commerce and what led to e-governance? This is that section 4. Where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then, notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form, accessible so as to be usable for a subsequent reference. So Section 4A has enabled e-commerce and e-governance in this country. If there is no Section 4A of the IT Act, there cannot be or there can be disputes regarding the e-commerce and e-governance. Section 6 makes it more and amplified manners that the government agencies can use electronic forms and electronic payment gateways to provide their services. But there is a caveat that although the government agencies can provide their services in the electronic mode, but it does not mean that they will only be electronic. That does not mean that physical will still remain valid. And a very, very important section from the perspective of the compliance professionals, the advocates, the company secretaries, the chartered accountant, I keep on getting a lot of questions whether the contracts done in an electronic mode are they valid, or whether the contracts done in an electronic mode are they valid. Section 10A. Validity of contracts formed through electronic means. There in the contract formation, the communication of proposals, the acceptance of proposals, the revocation of proposals, and acceptances, as the case may be, are expressed in electronic form or by means of an electronic record. Such contracts shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for a purpose. So this amendment in section 10, as an insertion section 10, it came in 2008 because there was some confusion that during the process of reaching to a contract, all those communication, proposals, acceptances, revocation, acceptances, etc., including payment. What if they are made through electronic mode, say over email, WhatsApp, etc., etc.? Can they be sufficient ground for that contract to be validly formed? Obviously, it is not otherwise unenforceable or illegal contract, but if that contract is otherwise legal, can the proposals, acceptances, revocation, payment, etc., considerations, if they are electronic form, can these contracts be enforceable? And this section very clearly has answered this question. I'm sure everybody would have now fully understood the context in which the IT Act allows the performance of e-commerce, commerce through electronic mode, contract through electronic mode, and entire e-governance which we are seeing. The proliferation of e-governance, almost all the government services now are available online, be it NCA, be it GST, be it income tax, any kind of a registration you want, any application you want to make, you want to reach out to your officials, they are now through electronic mode. IT Act 2000 through various sections, especially section 4, 6, 7, 8, 9, 10, 10A, has facilitated e-governance and e-commerce and commerce through electronic means. Otherwise, legally it would have been difficult to enforce all such transactions if entered through electronic means. Now we will discuss and move upon the criminal part of the uh, cyber law IT Act. What if somebody is not going to adhere to the golden rules of doing business, somebody who is trying to commit a crime, as we have seen in the earlier definition of crime, somebody who is trying to commit a cyber crime or crime through electronic means, what are the penal provisions, what are the remedies available as per the law. And there is a very famous case which was among the first cases for the conviction of a cybercrime case, which was called Baji.com CEOS case. Baji.com was later on acquired by eBay and acquired by the company. This case was very simply speaking, two school kids recorded a pornographic clip on their mobile phone and shared it as an MMS. Another student received the clip and posted it on Baji.com for auction. When this was discovered, the cybercrime police arrested Avnish Bajaj, the then managing director of Baji.com, and the student as well as the juvenile under section 67 of the ITA, publishing of information which is obscene in electronic form. Now it is very important to know why Mr. Avnish Bajaj, who was the managing director and who actually was not directly involved in publication of this information, probably he was not even aware that there is some pornographic material has been put on their website, their company's website for auction, etc. He might not be aware because on an auction website you keep on getting a lot of information, lot of sale purchase kind of stuff. It is not to be understood that the managing director will not be having information about all these things which are coming on their website. So section 85 of the company of the IT Act puts the vicarious criminal liability on the key managerial personnel, KMPs. Section says where a person committing a contravention of any of the provisions of the Act or of any rule, direction, or order made under is a company, every person who at the time the contravention was committed was in charge of and was responsible to the company for the conduct of business of the company as well as the company shall be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. So there is a vicarious criminal liability fastened upon the KMPs for all the offences committed by the company. Since we are having less time, we will try to go and discuss some of the key points. Now, there are various offences which are defined. Some of them are that if any person without permission of the owner or any person who is in charge of a computer, computer system or computer network accesses or secures access to such computer, computer system or computer network or computer resource, downloads, copies, extracts any data, introduces any viruses, does any damage or in any manner disturbs the working of that computer, computer system, computer network, or steals data, introduces any kind of a virus, any malware, or disrupts the working, that person can be liable to pay damages by way of compensation by the persons who affected. And the person here can be a company. So a company can be an aggressor, a company can be an aggrieved. Now section 43A, which is very very important from the perspective of the corporate and small businesses also, partnership firms, chartered accountant, company secretary, advocate firms, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates is negligent in implementing and maintaining reasonable security practices and procedures, and thereby causing wrongful loss or wrongful gain to any person. Such body corporate shall be liable to pay damages by way of compensation to the person so affected, and that compensation go up to 5 crore for each and every person. And that sensitive personal data can be Aadhaar data, PAN data, any kind of a health data, any financial data, or anything which can be considered as a sensitive personal data. It's a matter of interpretation only. There is no definition, exact definition given, but it can be anything which can be held as such by the authorities or court of law. Now, this act has a very interesting proposition that all the civil offences which are defined elsewhere can be considered as criminal offences if any person dishonestly or fraudulently does any act referred to in section 43. So the liability can also be criminal. Earlier there was a 5 crore rupees penalty or compensation clause were there. Now for a similar offences, a person can be tried criminally and a punishment of 3 years imprisonment can also be imposed if that act has been done dishonestly or fraudulently. And dishonestly and fraudulently is as defined in the Indian Penal Code section 24 and 25. Some of the other criminal offences 66B, punishment for dishonestly receiving stolen computer resources or communication device. 66C, punishment for identity theft. Whoever fraudulently or dishonestly make use of electronic signature. So if a company secretary, chartered accountant is affixing a digital signature for their client, and later on that client or the director disowns that and saying that the company secretary has done it dishonestly, fraudulently, they can be imprisonment. They can be imprisoned for 3 years. 66D. Punishment for cheating by personation by using computer resource. 66E. Punishment for violation of privacy of private parts. And 66F is cyber terrorism. Pornographic cyber crimes, punishment for publishing or transmitting of material containing sexually explicit etc. in electronic form. Whosoever does it, the punishment is 5 to 7 years, and obviously some fine is there. And this is more severe in case of juvenile children. Tampering with computer source document is also a punishable cyber offense. Penalty for breach of confidentiality and privacy. This is separately mentioned, and even for a government officer or an auditor, if he gets to get some information during the course of their normal business activities, they must not disclose that information without the first obtaining the consent from the party whose information is given in their homes. The penalty is 1 lakh rupees and the punishment is up to 2 years imprisonment. Section 506 in the Indian Penal Code, the communication for threat or criminal intimidation can be in the electronic form. The POXO also section 14, 15, the electronic means if they are used, the punishment is very much there, child pornography, etc. And all the offences prescribed in the IT Act are cognizable. That is, the person can be arrested without getting a warrant. This Act to apply for offence or contraventions committed outside India, so it has a global reach. The police officer and other officers has the power for a search and seizure in any place which they consider as a public place. So this act is pretty strong in terms of search and seizure, and it has an overriding effect. Being a specific act, so it will have an overriding effect as far as IPC or the other criminal law or the criminal acts are concerned. And it also provides for punishment for anybody who is helping others to commit any kind of a cyber crime. So it is not only that you yourself is doing any kind of a crime. If you are helping other parties to do that cyber crime, that also is held liable. Section 84B, abatement or attempt is also punishable. We will very quickly discuss about the evidence part or the cyber trial or the digital trial. Just give me a second. Just give me. Now the major principle of evidence is that of the best evidence rule. That is, original and first-hand account documents can be deemed to be most reliable and are considered primary evidence. Atyatam Saksh Niyam. You can say in Kannada. I'm sure all of you must be able to understand the best evidence rule, Atyatam Saksh Niyam, which is also called Uttam Saksh Niyam or Sarvotta Purva Niyam. What is the primary evidence? Section 62 states primary evidence means the document itself produced for the inspection of the court. And according to section 64, documents must be proved by primary evidence except in the cases hereafter mentioned in accordance with section 65, which states that secondary evidence may be given of the existence, condition, or contents of the document in the following cases. And please understand that by an implication in the IT Act, electronic documents are also now documents. So that is again the implication of the IT Act, that all electronic documents have become documents for the purpose of the Evidence Act and for the electronic trial. Now what the section 65 says differentiates between existence, condition and contents of a document, whereas existence goes to admissibility of a document. Contents of a document are to be proved after a document becomes admissible in evidence. So the electronic documents admissibility itself is a law in itself. In next few minutes, before we close, we are going to discuss in very brief that how to make an electronic document admissible. Although an electronic document is a document for the purpose of Evidence Act, but its admissibility is through a different provision of the law and has a certain procedure. 65A speaks of contents of electronic records being proved in accordance with the provisions of section 65B only. And section 65B speaks of admissibility. So what is that? 65B2 refers to the conditions that must be satisfied in respect of a computer output and states that the test for being included in conditions 65B2A to 65B2D is that the computer will regularly use to store or process information for purposes or activities regularly carried on in the period in question. The conditions mentioned in subsections 2A to 2D must be satisfied cumulatively. So, for a electronic document to be admissible, conditions provided in section 65B 2A to 2D must be fulfilled, and a certificate as per section 65B4 must be provided for electronic records to become admissible as an evidence. Whether it is to be proved, the basic tenets for proving an evidence, proving the contents remain the same. But until and unless an evidence is admitted for the purpose of a trial or a suit, it cannot be appreciated. For an appreciation of a piece of an evidence or a document, it must be first admitted through the law. And for an electronic evidence to be appreciated as a document later on, it has to be admitted as per section 65B 2A to 2B, and a certificate according to 65B4 must be produced. The procedure, as we have discussed, 65B 2A to 21 to 2D. Today we do not have time for the SOP, standard operating procedure of these. We will discuss at some other time. Now, regarding the admissibility, we have certain important case laws. I will take another 2 minutes before I finish. So, the first case in which this matter came up before the Honorable Supreme Court was State of Delhi versus Navjot Sandhu, Afzan Guru. That was the Parliament attack case. And the Supreme Court says there is no need for a 65B4 certificate, and an electronic evidence can be admitted like any other document. Then came the other case, Anwar P versus PK Bashir, and Honorable Supreme Court says no. 65B4 certificate and the procedure maintained 65B 2, 1 to 4 is mandatory. There cannot be any letter. That is the procedural law provided by the IT Act. It has to be adhered to. Sorry, Evidence Act. It has to be IT Act. It has to be adhered to. Then there is another case, Safi Mohammed versus State of Himachal Pradesh, and there was some confusion coming to the mind of the people that Supreme Court has again relaxed the requirement of Section 65B4 in terms of admissibility of the evidence. Actually, it was not. And they have now made it very clear in this recent case, which was pronounced on 15th July last year, Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorintyal and others. In this particular appeal, that for admissibility of a digital evidence, electronic record, 65B4 certificate is a mandatory. You simply cannot say that because I cannot fulfill this requirement, I will not do it. That is not at all acceptable. There is another important case which I think everybody should know before I finish, and this case is Tomsro, Bruno and Nadar, State of UP, Criminal Appeal number 142 of 2015, where Honorable Supreme Court has said that with the advancement of information technology, scientific temper in the individual at the institutional level is so pervade the methods of investigation, and it says that the police inspector saw the full video recording of the fateful night in the CCTV camera. It was a murder case, but he is not recording the same in the case diary, and that was one of the key reasons that the accused got reprieve and they were set free in this particular case. So if there is an electronic evidence available in any case, civil or criminal, there is a must It must be produced during the trial as per the judgment in the Commerce of Guru and other uh, criminal appeal number 142 or 145. So I think for today we have had enough. There is obviously a lot of other things I wanted to discuss with you, but time is of essence. We have limited time, and we cannot continue like this. I think we will have some other session to discuss all these things later on. Thank you very much. And now you can see my videos and interact with me through this YouTube channel of mine, Anuj Agarwal Cyber. You can search me easily on the Google. And this is my 9810347977 is my WhatsApp number. You can always connect to me through my WhatsApp number. Thank you very much.
Sir, thank you, sir. We have some question and answer session from our member, sir.
Yes, please.
Uh, One of the senior member who is the chairperson of past chairperson of our chapter, Shahaba Madam, currently she is having around 2 to 3%, sir. Madam, please go ahead.
Sir, one of the questions which I had posted was you were talking about signatures. While we are all used to using the digital signatures, of late we also find something called DocuSign. Personally, I don't think it is to be. It's not an electronic signature, but in many legal transactions also in agreement signing, people are using that DocuSign. What is your view about that?
As you rightly said, and I have also mentioned that only digital or the electronic signatures as per Section 3 of the IT Act and as prescribed in Schedule 2. And I don't think this particular commercial technology which they are claiming is notified in either Schedule 2 or is as per Section 3 provisions of the IT Act. So if there is a challenge to these electronic contracts arise anytime, I think they will have difficulty proving the authentication. There will be difficulty.
According to you, it's only the digital signature which can be used.
No, I'm saying electronic signature as prescribed as prescribed under Section 3 of the IT Act and as notified under Schedule 2 of the IT Act, they only are allowed. And to my knowledge, there are only two. One is obviously digital signature, which we all use, and then there is a UIDI based authentication mechanism that has also been notified in the Schedule 2. So these are the two, this eKYC, which is enabled by the UIDI. So these are the two mechanisms which are currently notified.
I have one more question, sir, because now, because of the pandemic, all of us are working from home. Employees are all at different cities, different places, so are vendors and customers. I remember you showed us one picture where you said you should use the VPN system, but apart from that, any basic security measures which you can share with all of us?
See, what I can tell you, and you please note down, there is an endpoint security. See, this is the least one should be do. So there are various endpoint security solutions available in the market. One can buy and implement on the computers, on the laptops. Okay. And one of the examples I am giving you is this particular software. So this particular software you can buy and you can use because obviously people are working from home and they are connecting with vendors, they are connecting with customers, and there is very little control. So whether inside the organization, when you are working as a company, or whether you are working from outside, you are having a firm or a corporate, endpoint security is a must. VPN only helps you in connecting securely or rather authenticating the person who is coming to the corporate network. So VPN has a very limited role. So endpoint security solution, for example, Satisfy is just one example. There are other brands also in the market. One should implement that. That will give you You see, that will give you security from virus, Trojan, and all sorts of hacking. Also, it will also help you track your employee productivity, what they are doing, whether doing something good or not so good, whether they are watching movies, whether they are doing office work, and what kind of things whether they are downloading any unauthorized software and all that. So these are the things I'm sure you must keep in your employee and your computers.
Thank you so much.
Okay.
Thank you, madam. Now I request Harita Ji madam to post her question.
Yes, sir. Thank you, sir. Yes, sir. Thank you, Anuj, sir. Thank you, sir.
Thank you, ma'am.
Sir, generally, how do the data in the WhatsApp or mobile or any other electronic mechanism will it be traceable to the regulatory to detect it? If it is in a kind of a crime situation, generally, I am talking from the perspective of child abuse. Does it work like a DNA trace, unlimited time period? Because the technology keeps changing every now and then. How do I need to?
Well, there is no silver bullet answer to that. But yes, in most of the cases, it is traced, and these child abusers or these kind of people. See, it is in fact it is easier to trace criminals in the electronic mode. So anybody who is thinking that he is anonymous and he is able to commit a crime, child abuse, or some kind of a data theft or financial theft, and he can get away, I think that is a false notion.
Thank you, sir. Thank you so much.
Very good.
I request Sanjay. Thank you, Harita madam. I request Sanjay Suri to ask his question. We posted it in chat box.
So question है, YouTube में.